So right to constitutional remedy or writ jurisdiction. When we talk about writ jurisdiction or jurisdiction as such, it means the extent of power. Okay, jurisdiction is of different types, like there is territorial jurisdiction, to what area the court will have jurisdiction. Like if you say Supreme Court, it's having territorial jurisdiction throughout India. If you say High Court of Karnataka, it's having territorial jurisdiction in the state of Karnataka. Like that, we have subject matter jurisdiction also, right? So when we say subject matter jurisdiction, Supreme Court and High Courts are having writ jurisdiction. Writ petitions can be filed there under Article 32 in the Supreme Court of India directly, and under Article 226 in High Courts, we can file a writ petition. So when we talk about fundamental rights, these rights are guaranteed to us, and in case they are violated, we can directly go to Supreme Court of India. For other different provisions, we would go to the lower courts. If we are not happy there, then we move to the Supreme Court. It's like a gradual process, but for violation of fundamental rights, we can directly move to the Supreme Court of India. So what is writ? A writ is nothing but an order by the court directing lower court to either do something or not to do something. It may be giving a direction to the court, or it might be giving directions to a certain department of the government, a certain public employee, etc. Constitution of India empowers Supreme Court and the High Courts to issue such writs. And when we talk about writs, there are 5 different types of writs available. Under Article 32 of Constitution, it deals with constitutional remedies that a Indian citizen can seek directly from Supreme Court of India. We can directly go to the Supreme Court of India and file a case under Article 32 of Constitution for violation of fundamental rights, because these rights are guaranteed to us. And under Article 226 of Constitution, we can move to the concerned High Court. If we are living in Karnataka or the matter has taken place in Karnataka, we will go to Karnataka High Court. If it has taken place in some other place, their respective High Court, we can approach for violation of any other provision of Constitution, including fundamental rights. For other provisions, we cannot directly go to Supreme Court. We need to first go to High Court. But for fundamental rights, we can directly go to Supreme Court, or if we want, we can go to High Courts also. There are 5 types of writs that can be issued by the court, and these are the 5 writs that we get to see under Article 32. Habeas corpus, mandamus, prohibition, certiorari, and quo warranto. It's important that we know the meaning of these different writs and where it applies. Okay, so where it applies and to remember the meaning, there is just one word that you need to remember for each of these. Okay, if you are able to remember this one word, you will be able to recall what this certain type of writ is all about. Okay, so we have habeas corpus. Have you studied writs anywhere before?
No, ma'am.
No. Okay. So when we talk about habeas corpus, see, this is what I have underlined, right? If you remember this one word, you will be able to recall what this certain writ is all about. So just try to remember this part at least. So habeas corpus is a Latin word which means you have the body or produce the body or to have the body. Okay, so what is meant by to have the body? This type of writ is issued in case of illegal detention and imprisonment. Illegal detention and imprisonment, this writ is applied. This writ allows the court to direct the detainer to appear before the court and give a valid reason for the imprisonment or detention. They must provide proof that is legal. Thus, the onus of proof is on the detainer, and he must show proof of authority to do the same. If the court finds that the person has been illegally detained, it can order the detainee or the prisoner to be set free. Now, when a person is arrested or when a person is detained, there are certain rules, regulations, or guidelines that needs to be followed. Like when one person is arrested, he needs to be informed about the ground of his arrest. Then proper procedure should be followed in the arrest also. Then he should be produced before nearest magistrate within 24 hours. A lot of guidelines are there. In case a person is simply arrested and kept in custody. He is not being released. He is not produced before magistrate. He is not allowed to consult an advocate. In such cases, we will say that his detention or his arrest is not proper. Right? He should have been produced before the magistrate. After 24 hours, magistrate's permission should have been taken to detain him further. Those things are not being done. In such cases, what is happening? It's a violation of fundamental right of the person. It's a violation of Article 21, right to freedom, right to personal liberty. So there we can file a habeas corpus petition wherein court will say that produce this person before us, as in to have the body, produce this person physically in front of us, and then we will see on what ground he was arrested. Is that ground justified or not? We will analyze it. If court feels that okay fine, he was arrested on genuine grounds, court might say that okay fine, this detention is genuine, this imprisonment is genuine, keep him in custody. If court feels that the ground of arrest are not proper, their court may even ask that set this person free. Why was he arrested? His ground is not proper, release this person. His right to freedom, personal liberty is being violated. This is nothing but habeas corpus, to have the body, to produce the person before the court so that court can see whether the ground of arrest is proper or not. There was a case, Sheila versus State of Maharashtra, wherein court expanded that it's not necessary that whoever is arrested or whoever is detained, that person should be the petitioner. It's not needed that that person should be filing the case. An interested party who has some connection with the case may also do so. That person may also file a case saying that this person is being arrested and the ground of arrest is not genuine. He should have been released. He is not being released. There, someone else can also file a case on behalf of the person. Okay, there was one case, Husseinara Khatun versus Home Secretary, State of Bihar. In this case, one petition was filed by an advocate, Kapila Hingorani. Okay, she filed an application. She filed a petition, writ petition before court, and she said that a lot of prisoners, a lot of people who are there in the prison, they are simply arrested and being detained. They are still waiting for their trial. They are detained for a very long duration. There, a lot of prisoners were released by Supreme Court of India because the ground of arrest was not found to be genuine. Okay, so like that, someone else can also file a case on behalf of the person. Some interested person can also file a case. Okay, so habeas corpus means to have the body, produce the person before the court so that court can see if ground of arrest is genuine or not. If not, he can be asked to be released also. Okay, is it clear?
Yes, ma'am.
Next is
Yes, ma'am.
mandamus. Next is mandamus, which means to command. Okay, we command or to command. So literal meaning of this writ is we command or to command. This writ is usually issued by the court to order public officials. So this is given usually to different officers who are there in different departments of the government, right? Usually to them this writ is issued. So court will order public official who has failed to perform his duty or refused to do his duty or to resume his work. Now, India is a welfare state, right? When we say welfare, India has different schemes for welfare or benefit of people, right? There are so many schemes that provide scholarship to SCs, STs, other weaker sections. There are so many schemes that are providing benefit to aged person, so many schemes providing benefit to unemployed youth. A lot of schemes are there, and these are nothing but for welfare or for benefit of someone. Right, so when we talk about the different departments that are there in India, whether central or the state government departments, the people who are working there, right, they have a lot of duties towards the public. Because if someone is working in social welfare department, if the person do not put his signature, sanction it, the common people are not going to get benefit under a certain scheme, right? So this person who is employee in social survey department of social welfare, he is having a responsibility to put his signature on the forms or applications that are submitted by common people. If I am entitled to some sort of a scholarship, I have submitted the form properly, all the details filled, all the documents submitted. Now I am approaching a concerned officer there in social welfare department, and the person is simply not putting his signature. He is not giving me any reasons also. Everything is fine, but he is not putting his signature. In such a case, I will not be able to get the benefit of the scheme, right? So what I can do is I can file a writ petition of mandamus by approaching the court, and then court will see, okay, I need to prove that this person is a public officer, he is having this duty, I have filled the form properly, he is not giving me any reasons and simply not putting his signature, as in he is a public officer, he had a duty towards the public, he failed to perform his duty, as a result I have suffered. In such a case, what court will do, if court is satisfied with my grounds that yes, that is genuine whatever I have said, court is going to command this person that you perform this duty. If there is no problem with the form, if the documents everything is submitted, you put your signature, why are you not putting it? Right? Court is going to order this person so that I am able to get the benefit under that certain scheme. So mandamus is also very common that is being used. Besides public officials, mandamus can also be issued against public body or corporation, inferior court, a tribunal, and government for many other purposes. For different matters, if they are not performing their function, there we can approach the court by way of writ of mandamus. For example, I have applied for passport, all the documents are submitted, all the details I have given, everything is done, but I'm not getting my passport. I have waited for 1 month, 2 months, 3 months. After that, what should I do? Because they have not given me any reasons also why it's not being issued. Right there, we can file mandamus, wherein they had a duty to issue the passport, they are not doing it, so they need to issue it, or they need to give a proper reason why it's not being issued. Okay, you must have heard of Right to Information Act, right?
Yes, ma'am.
So what is this legislation all about?
So if general public wants to know about any certain information which is publicly available, whether it is related to government or other things which is publicly available, then we can go and ask for those kind of information using this Right to Information Act.
Correct. So we can ask for that information. And usually when you open any government website, right, you will see one section on the website which says RTI or Right to Information. There they would give details of the concerned person. Like in almost every single department or every single office, they will appoint 1 or 2 persons minimum who are having the responsibility of providing information. So their names, details, phone numbers, etc. would be given, that in case you want any information from this office or this certain department, you need to address your letter to this concerned person, right? So like that, a specific person is being appointed. Now, for example, you want some information from UGC, University Grants Commission, and you have applied for it to the concerned person. Now, if the concerned person is like, I don't want to provide you the information, I'm not providing. The person has not provided you the information, the person has not given you any explanation also. Like if it's something which is not like publicly, which cannot be publicly shared, or which do not fall under the definition of information, they need to mention it that I cannot provide you this information because of so and so reason. If that person appointed under UGC is not providing you information, not giving you any explanations, in such cases, what do? Under RTI, you have option of filing first appeal, second appeal. If everything you have tried, the person is not providing you information, you can file a writ petition under mandamus that this person had a duty of disclosing so and so information. He is not doing it. Like that, a lot of people file cases when they are not satisfied with RTIs. It's nothing but mandamus, wherein court will command or order a person that this is your duty. You have not performed your duty without any logic, without any reason. You need to perform it. We command you to perform your public duty. Okay, so there is this case, State of West Bengal versus Nuruddin. The Supreme Court held that writ of mandamus is a personal action wherein respondent has not done the duty they were prescribed to do by law. The performance of duty is the right of the applicant. Like I mentioned, right to information. I have a right to seek information, and the person is not providing. Even being a officer appointed for that purpose, he is not providing it. So in such cases, writ of mandamus can be filed, wherein court will give direction. Okay, is it clear, mandamus?
Yes, ma'am.
So habeas corpus means to have the body produce the person before court so that court can analyze if ground of arrest is genuine or not. Mandamus is we command or to order or to command, wherein court will command a person or a public officer that you perform your public duty, otherwise people are going to suffer. Next two writs are similar to one another, but there is one point of difference: prohibition and certiorari. When we say prohibition, it originates from the word like prohibit. Prohibit is like restrict, right? So the literal meaning of prohibition is to forbid or to ask someone to stop doing something, okay? To stop or to forbid. The Supreme Court or High Court can issue a writ of prohibition against a court that is lower in position to prevent a lower court from exceeding its jurisdiction that it does not possess. It directs inactivity. When we talk about jurisdiction, like I mentioned, there are different types of jurisdictions: territorial jurisdiction, subject matter jurisdiction, pecuniary jurisdiction. Maximum what punishment can you give as a certain court? That's also nothing but jurisdiction. So maybe a case is being filed, okay? Like we are from Karnataka, there is a dispute between you and me. We should have filed the case in Karnataka. But what we did is we filed a case in Punjab, some lower court in Punjab, and that court has entertained the matter also. In such cases, what happens? It is going beyond its jurisdiction. Punjab court actually was not having jurisdiction, right? It is still entertaining the matter. Or maybe a certain case had to go to sessions court. Okay, in Bangalore sessions court, it had to go to. We filed a case in magistrate court, and court also entertained the matter. In such cases, also, it's going beyond its jurisdiction. Or maybe it is not following the proper process. Okay, like what happens when you are deciding a case, you need to hear both the sides before giving a decision. So if court is saying that no, I'm only going to hear the petitioner, respondent I'm not going to hear, in such situations this writ can be applied. Okay, if there is any problem with the proceedings of the court, this writ can be applied, which is prohibition. Okay, and when can you prohibit something? When it is still going on, right? Then only you can ask the person to stop. If it has already ended, there no point of asking the person to stop, right? So prohibition is applicable for a case which is ongoing. Okay, ongoing case is still going on, it has not been finally decided, and something is wrong in between. There we can file a case for prohibition, that this court is going beyond its jurisdiction, or this court should not have done this sort of a thing. There higher court will ask that you need to stop doing this. This is not right. This is beyond your jurisdiction. Leave it right here. That's nothing but asking to stop or to forbid. And remember, it is for ongoing cases only. There was a case, Kolkata Discount Company Limited versus Income Tax Officer. The Supreme Court held that when a subordinate court or tribunal is shown decisively that they have acted in excess of their jurisdiction, the court will issue a writ of prohibition regardless of whether there exists an alternative remedy or not. So a court is going beyond its jurisdiction. That is what would matter. After that, where parties will go, what they will do, those things court is not going to take into consideration. Okay, court is going to mainly take into consideration that no court, no tribunal, no judicial body should go beyond its jurisdiction. That should be the prime focus when we talk about prohibition. Okay, so this is applicable for ongoing cases. It means asking a lower court to stop or to forbid a lower court from proceeding with a certain type of case. Opposite to that or similar to that, there is some similarity also, is certiorari. Certiorari is like certified, okay, to certify. So the literal meaning of certiorari is to be certified or to be informed, letting someone know or to certify something. Okay, so this writ is issued by Supreme Court or High Court to a lower court or tribunal to quash their order or decision in a case. When we say decision in a case, that means it's already being decided, right? Case has already been decided. Are you aware of the difference between these two words, judgment and order?
No, ma'am. Completely not aware.
So when we say judgment, right, it's like the final decision. Like if a case is filed that so and so person has killed another one, in the judgment, court will say, okay, fine, he has killed, it is being proved, this is the punishment. That's like judgment, finally what is decided in a certain case. Okay, but before the case is finally decided, there will be lot of hearings going on, right? For many years a case goes on, so many hearings are there. In in those hearings, court may pass some orders, court might ask parties to do certain things, etc. Those are called as orders, which are in between giving some orders or directions. Okay, so when the case is going on relating to murder, court might say that, okay, we are passing an order that this person, right, this accused person, police officer need to keep an eye on this accused person. Police officer need to see that he is not tampering with the evidences, or he is not trying to meet the witnesses or the victim or something like that. Okay, so that's nothing but an order. Court might order the accused person that until and unless this case is decided, you should not go and meet family members of the victim. That can be an order. Court is asking this person to do something, right? But it is in between the case it is happening, it's not finally decided, right? So it can be relating to a judgment also, it can be relating to an order also, that certiorari can be applied. Sometimes court might say that for a property matter, okay, that until and unless we decide who is rightful owner of this property, no one should live in this property, this property should be locked and kept like that. Okay, maybe there is a property which is being rented out, and now there is a dispute between two brothers who is the real owner of the property. Court might say that you cannot rent it out until and unless the case is decided, keep the property unused until it's decided. That's nothing but an order. Okay, is it clear or confusing?
Got it, ma'am.
So when we talk about certiorari, it can apply for both judgments also, it can apply for orders as well. Okay, so what happens, court might pass an order that do not use this property or something like that, do not meet the victim's family, something like that. If you feel that it's not justified, there you can approach a higher court, whereby higher court would quash that order or decision. As in, higher court would certify that whatever lower court said, we are setting it aside, we are canceling it out, we are quashing it, it's not applicable, it's not valid. Certiorari is a very common writ that is filed by parties. Okay, sometimes they will also file this writ. Maybe an FIR is being registered. Okay, I have lodged an FIR against a certain person, and the person thinks that this FIR is not genuine. Okay, this FIR is not genuine, completely based on false grounds. There, this person can approach the court by way of certiorari, saying that you need to quash this FIR because this FIR is not genuine. And if court feels that yes, this FIR is not genuine, court is going to quash it also. Okay, this is like a very common writ that is being issued by courts. So this would apply in terms of maybe decided cases or maybe pending cases. Because if it is, we want to quash a certain judgment, it will be a decided case. If we want to quash an in-between order, it might be a pending case. So certiorari can apply for pending also, for disposed also. But it's that something court has said, court has passed an order, court has passed the judgment. But here we want to ask the court to stop the process itself. It's not the right court where case is going on, right? So we want to stop the lower court. That's why we are filing prohibition. Here we just want to make a certain order or judgment invalid, setting it aside or quashing it. That is very important. So it is issued on the grounds of an excess of jurisdiction, going beyond our jurisdiction, or lack of jurisdiction. It was not the right court having jurisdiction, or maybe error of law. Some problem is there with the law, we can approach it. It not only prevents but also cures fraud or mistake in the judiciary. Court might say that no, whatever lower court said, it's not valid. This is not going to be applicable. We are setting it aside. Many cases you will see like that. High court would say lower court has given this decision carelessly. Lower court has not taken into consideration the evidences, grounds, this, that. We are setting it aside. Like that it happens. It's nothing but certiorari. Okay, so scope of certiorari has been given in this case. Hari Vishnu Kamath versus Ahmed. In this case, the scope of writ of certiorari was given that when there is an error of jurisdiction, wrong court we approached, and court also entertained the matter. Or when the court has not given proper time for both the parties to be heard, or has violated principles of natural justice. Both the parties should be heard. Whatever decision is given, proper reasoning should be given. If those things are not being followed, there also we can approach the court for certiorari. This writ is supervisory in nature, so High Court cannot review the findings of the lower court. So it just supervises that whether it is genuine or not, and court would simply say that this is not proper on so and so ground, maybe because evidences were not taken into consideration, or it's going beyond jurisdiction. So we are cancelling it out, we are setting it aside. If the error is evident, we need to show why is this certain thing not correct. There only court is going to certify, there only court is going to issue writ of certiorari. Okay, so habeas corpus, produce the person so that court can analyze if ground of arrest is genuine or not. If not, the person may be asked to be set free. Mandamus, we command. Court is going to command some officer, some employee, some court, or somebody to perform its public duty, because otherwise people are suffering. Prohibition, to prohibit a lower court because the case is still going on. To ask the court to stop the proceedings, prohibition will be applied. Certiorari, to be certified or to be informed. Already something is being decided, a judgment or an order has been passed. So court is going to issue this writ to certify or to inform that this certain order is not valid. We are setting it aside, we are cancelling it, or we are quashing it. Okay, is it clear till here?
Yes, ma'am.
Okay, so are you aware of this term, show cause notice?
Yes, ma'am.
What is that?
So, court will send a notice to the party to get the understanding from the party to the party should explain why he should not be sued, or why he should not be given such order, or whatever it is.
Correct. Show cause notice, very common. Income tax authorities also send, right? Show cause notice. Why you should not be fined, because we think that you have not paid this much income tax or something like that, right? So show cause notice is very common. Now we have a writ of quo warranto. What is quo warranto? It means by what authority or warrant? Like, what is your authority? Someone is asking that. The Supreme Court and High Court can issue this writ to prevent illegal holding of a public office by a person. When we talk about public office, like there are different departments, within that different designations are there, different posts are there, and they will have some minimum qualification or criteria, etc. Right? So might be, just as an example, just take that there is passport office wherein there is passport officer, maybe, okay, and just an example, okay, maybe the minimum qualification for passport officer is post graduation, so he must be a postgraduate. Now I visited the passport office and I have seen that the passport officer there is just an undergraduate. Now the question comes to my mind that if the minimum eligibility is postgraduate, how come this person is holding this public office being an undergraduate? Okay, so I can file a case over there that by what authority you are holding this public office. What is your authority? How come you are holding this office? In such a case, this person will have to give explanation. How come he is holding? He might say that, yes, this is what the general rule is, that usually the person must be a postgraduate. But there is a provision that if somebody has cleared public service commission exam, then they can be an undergraduate also. I have qualified public service exam. That's why I'm appointed as a public officer even after being an undergraduate. Like that, they need to explain, otherwise this person would be removed. Okay, so it can be for a public officer who is holding a certain public office, there we can question, or sometimes it might happen that actions of a public officer, okay, maybe there is a certain department, okay, just an example, maybe some labor department, okay, there is labor department. What has happened is, in labor department there is a rule that only maybe the director can issue notifications. Okay, only the director is having authority to issue notifications. One day I saw labor department's website wherein a notification was published and the undersigned was assistant director. So now the question comes to my mind that only the director was having the authority to issue notifications. How come assistant director is issuing a notification? What is his authority? How is he issuing the notification? How is he the undersigned? If I ask such a question, if I find such a case, this person can give an excuse that, okay, fine, usually the director is having the power to issue notification, no one else is having, but there is a condition that if the director is absent for 1 month or more, in such cases assistant director gets that authority, not before that. 1 month or more, then only he would get. So like that, there may be some exceptional situations and that needs to be proved. Okay, otherwise quo warranto means by what authority you are holding a certain public office, or by what authority you have done this certain thing. So through this writ, the court inquires into legality of a claim of a person to a public office, whether it is legal for a person to be holding this designation of passport officer or not, that court is going to identify. Okay, there was this case wherein the court held that a private person may file an application for a writ of quo warranto. It is not required that this person is personally affected or interested in the case. I might have simply visited the passport office for some purpose. It's not like I am affected because this person is undergraduate and he is being appointed or something like that. It's not like that. But I might be just a normal person who can file a case also. Okay, is it clear, quo warranto?
Yes, ma'am.
Yes, ma'am.
So by what authority a certain position is being held, or by what authority a certain action is being taken by done by a person. So writs are very much important because it's like a constitutional guarantee, right to constitutional remedy. Constitution itself is providing for a remedy, or constitution itself is guaranteeing that we will for sure be able to enjoy our fundamental rights. So it's given under Article 32 to Supreme Court, 226 to High Courts, and it protects rights of citizens by providing faster remedy and upholding the principles of quick justice. Quickly, the parties can go to the court, file a case, and get a remedy or a relief. Importance of writs cannot be underestimated, and the courts must necessarily use this power judiciously. Properly, they need to use this power so that people's rights are being protected over there. So it's there in that Unit 5 document. You can go through it once. Then the important thing is just remembering these certain things, okay? And then you will be able to explain it as well.